Hello everyone and welcome back to Courts This Week by LiveLaw. I'm Debojit and joining me as always is Advocate Ostika Das here. We've had another packed week in the courts, from a viral Andhra Pradesh High Court courtroom video that sparked outrage across the legal community, to the Supreme Court hearing the challenge to the Election Commissioner's Appointment Act, and continuing marathon hearings before the Sabarimala 9-judge bench. So, Ostika, let's get into it. For our first story, a video from inside a courtroom at the Andhra Pradesh High Court went viral this week and triggered a much larger conversation about how junior lawyers are treated in Indian courts. Ostika, what exactly happened here?
So, a junior advocate appeared before an Andhra Pradesh High Court judge, Justice T. Rajshekhar Rao, in a case involving a lookout circular and passport impounding. The lawyer cited a Telangana High Court judgment saying LOCs cannot continue indefinitely without valid reasons. Justice Rao then suggested that the Andhra Pradesh High Court itself had already passed a similar order and asked the counsel to produce it. Now, what the lawyer said next is still unclear, but the judge reacted sharply. Justice Rao directed that the advocate be taken into police custody for 24 hours, saying he had behaved indolently. In the video, the lawyer is seen standing with folded hands and visibly pleading, while the judge remarks that he was behaving like a senior advocate despite not even having 10 years of standing.
So, was the order actually carried out, and how did the legal community react?
The order was later recalled after intervention from the bar, but by then the backlash had already begun. After this video went viral, the Bar Council of India wrote to the Chief Justice of India seeking urgent intervention, calling the incident prima facie grossly inappropriate and warning that it could have a chilling effect on junior advocates across the country. The BCI has also asked the CJI to call for the courtroom video recording and has even suggested measures like judicial temperament training and the judge's transfer to another high court.
But that was not just the BCI, right? Other bar bodies and associations have also reacted.
Yes, including the Supreme Court Bar Association, which expressed what it called deep concern and shock and stressed that the relationship between the bench and the bar has to be built on mutual respect and institutional balance. At the same time, the Andhra Pradesh High Court Advocates Association says the issue has now been amicably resolved. But even if the immediate controversy has settled down, the larger debate this sparked, especially about how young lawyers are treated in courtrooms, is clearly not going away anytime soon.
Next, a case that brought acid attack survivor and activist Shaheen Malik to the Supreme Court this week and led to an important ruling for victims. Ostika, what happened?
The issue is actually a gap in the law. Under the Rights of Persons with Disabilities Act, acid attack victims are recognized as persons with disabilities, but only where the attack causes visible disfigurement. That left out victims who were forcibly made to ingest acid. No external burns, but devastating internal injuries nonetheless. And because of that, many survivors could not even get disability certificates or access rehabilitation benefits. Now, this week, the Supreme Court stepped in. A bench led by Chief Justice Suryakant extended the protections of the RPWD Act to these victims as well, with retrospective effect from the date the law came into force. The court also urged the union government to formally amend the law to make this position permanent.
Did the court stop there with that clarification?
Not at all. The hearing turned into a much wider discussion on acid attacks in India. The Chief Justice said there has been an alarming increase in both the number and brutality of these attacks, despite stricter laws being introduced in 2013. He even suggested reversing the burden of proof in such cases and making illegal acid sellers vicariously liable for attacks carried out using the acid they sell. Shaheen Malik herself told the court that acid is still openly sold on the streets of Delhi. Senior advocate Mukul Rohatgi, appearing for her, argued that compensation after a 10-year trial is meaningless for survivors whose lives are destroyed in their teens or 20s. The Solicitor General agreed with the concern and said delayed compensation is often too little too late.
Next, the Supreme Court ruling that should matter to anyone involved in a medical negligence case. Ostika, what was the question before the court?
The question here was simple. If a doctor dies while a medical negligence complaint against them is still pending, does the case end there? The doctor's wife and son argued that it should, saying medical negligence is a personal cause of action and under common law, personal actions die with the person.
And the Supreme Court disagreed here.
Completely. A bench of Justices J.K. Maheshwari and Atul Chandorkar held that the doctor's legal heirs can still be brought on record and the proceedings can continue. But there is an important safeguard. Their liability is limited only to the estate they inherited from the deceased doctor. They cannot be made personally liable beyond that. The court said the complainant still has a right to pursue compensation, but only against the assets inherited from the doctor. It also overruled an older 2001 NCDRC ruling that had treated such proceedings as ending completely upon the doctor's death.
The Supreme Court this week gave district collectors a direct role in tackling India's garbage problem. So what's this about?
This came in a case involving the Bhopal Municipal Corporation. The Supreme Court issued directions empowering district collectors to enforce the solid waste management rules, saying implementation on the ground has been extremely weak. The idea is basically this. Municipal bodies alone cannot be left to regulate themselves on waste management. The court wants senior district level officers to directly monitor compliance and ensure the rules are actually followed. This is part of a larger trend where the Supreme Court increasingly issues operational directions in environmental matters instead of only declaring legal principles.
The Supreme Court this week began hearing one of the biggest constitutional challenges in recent years, the challenge to the Election Commissioners Appointment Act of 2023. Ostika, what is this fight really about?
So at the center of this challenge is one key change. In the 2023 Anup Baranwal judgment, if you remember, the Supreme Court had said election commissioners should be appointed by a committee comprising the Prime Minister, the Leader of Opposition and the Chief Justice of India. Now the idea was to reduce executive control over appointments of election commissioners. But Parliament later passed a law replacing the Chief Justice with a Union Cabinet Minister. So now effectively the ruling government has a majority on the selection committee. The petitioners say that defeats the entire purpose of having an independent election commission. Senior advocate Vijay Hansaria argued on behalf of the petitioners that the ruling party has a direct stake in election outcomes and therefore cannot dominate the appointment process. He also pointed out that even MPs had raised the same concern during parliamentary debates, that once the Prime Minister and a Cabinet Minister are both on the same committee, the outcome is practically predetermined.
And the second day of hearings became even more interesting according to the reports.
Very much so. The bench remarked somewhat wryly that it wished judges were appointed as quickly as election commissioners. Now that comment came after the court was told that the leader of the opposition had been given a list of around 200 names on March 13th, 2024, and the very next day the committee met and appointed 2 election commissioners. Now the obvious question was, how is anyone expected to meaningfully evaluate 200 candidates overnight? Advocate Prashant Bhushan also argued that the parliamentary debate itself was inadequate because many opposition MPs had been suspended at the time the law was passed. And senior advocate Gopal Shankar Narayanan made a striking comparison. He said it was as if Parliament had responded to the Vishaka guidelines by passing a law that weakened them instead of implementing them. According to him, that is exactly what has happened here. The Supreme Court laid down a constitutional standard in Anup Baranwal and Parliament legislated around it rather than following it. That's all regarding this week's hearing. The matter will continue next week.
The Sabarimala 9-judge bench has now crossed 13 days of hearing, and what began as a case about women entering one temple in Kerala has turned into a much larger constitutional debate. Ostika, walk us through days 11, 12 and 13.
At the heart of the case is one major question: what does the word morality in Articles 25 and 26 actually mean? One side says it means public morality shaped through democratic processes. The other says constitutional rights cannot depend on majoritarian morality because society itself can often be discriminatory. That debate has run through the hearings this week. On day 11, the Indian Young Lawyers Association, which filed the original PIL, faced some sharp questions from the bench, with Justice Nagaratna asking why the petitioners were pursuing this litigation instead of focusing on helping young lawyers and disadvantaged members of the bar. Senior advocate Indira Jaising, appearing for the 2 women who entered Sabarimala after the 2018 judgment, defended the essential religious practices test. Her point was simple: if the court abandons that test, what replaces it? Purely subjective belief, and who then decides what counts as genuine religious practice?
Day 12 then shifted the focus to the Parsi community and the Article 26 rights.
Yes. Senior advocate Darius Khambata pointed to what he called a clear asymmetry in the Parsi community. Parsi men who marry outside the faith continue to retain access to the fire temple, while Parsi women who do the same are excluded along with their children. He argued that this cannot be justified purely on religious grounds. Advocate Ravin Srivastav then made a structural constitutional argument that really caught the bench's attention. He pointed out that Article 26 does not contain a non-obstante clause overriding individual rights under Article 25. In other words, denominational rights cannot automatically swallow individual fundamental rights.
And day 13 brought in the Dawoodi Bohra excommunication case.
Exactly. Senior advocate Raju Ramachandran argued that excommunication within the Dawoodi Bohra community has often affected deeply secular aspects of life, including marriage, property, and access to community resources. He argued that once that happens, it can no longer be treated as purely a religious matter, immune from constitutional scrutiny. The bench also made a few important observations during the hearing. It asked what happens to Indian civilization if every religious practice starts getting questioned in courts. At the same time, the court suggested that in the past it may have gone too far in completely striking down the law banning excommunication, hinting that the bench may now be looking at more calibrated nuanced solutions instead of sweeping invalidation.
That's our top stories segment. Let's move quickly through this week's quick updates. The Supreme Court is about to get bigger for the first time in 6 years, a move that could mean more constitution benches and faster hearings in pending cases. So how many judges will the courts now have?
38 in total, including the Chief Justice of India.
And how and when is this happening?
The Union Cabinet has approved a proposal to introduce a bill amending the Supreme Court Number of Judges Act 1956. So once Parliament passes the bill and it receives presidential assent, the sanctioned strength of the Supreme Court will go up from 34 judges to 38 judges, including the Chief Justice of India. Now the viewers should note the constitutional structure here. Article 124 of the Constitution itself provides for there to be a Chief Justice of India and originally kept the number of other judges at 7 unless Parliament increased it by law. So the office of the Chief Justice of India is constitutionally fixed, while the strength of the remaining judges is decided through legislation, which is why the 1956 Act talks about the number of judges excluding the Chief Justice of India.
Can courts impose caste-coded humiliation as a condition for bail? The Supreme Court had to confront that disturbing question this week.
So this case came out of Odisha, where Dalit and Adivasi villagers have been protesting in a proposed Vedanta mining project in the Tijimali Hills for the past few years. Now many protesters were arrested and in several cases courts have been granting them bail on the condition that they clean police stations.
That is outrageous.
And the Supreme Court clearly thought so too. In fact, the court stepped in on its own after media reports revealed that courts across Odisha have been imposing such conditions on Dalit and Adivasi protesters. So this was a suo motu case, meaning the court did not wait for a petition but acted on its own motion. The bench came down very heavily on this practice, saying this is not something one expects to see in 2026 and that such orders are bringing a bad name to the judiciary itself. While striking down these conditions, the court called them cruel, discriminatory and caste-colored.
So the Supreme Court this week ended up discussing a pretty uncomfortable question. Can the right of a transgender person to self-identify their gender somehow be misused?
This came up during hearings challenging the new amendments to the Transgender Protection of Rights Act, which were passed by Parliament and received presidential assent in March of this year. The main prong of the challenge is that the earlier law recognized a person's right to self-identify their gender, something the Supreme Court itself had protected in the NALSA judgment. But the new amendments move away from that and bring back medical evaluation for legal recognition. In that context, the bench did ask whether a system based entirely on self-identification could potentially be misused. But let me tell you, Senior Advocate Abhishek Manu Singhvi, on behalf of some of the petitioners, strongly pushed back, arguing that you cannot take away a fundamental right because of a small possibility of misuse. They said this is ultimately about dignity, autonomy, and the right to live as who you are.
So where does the challenge stand right now?
The Supreme Court has issued notice to the union government and the states and will now hear the matter in detail before a 3-judge bench, likely because the 2014 judgment in National Legal Services Authority of India or NALSA was delivered by 2 judges, Justices K.S. Radhakrishnan and A.K. Sikri. But for the moment, no interim relief has been granted since the law has not yet been formally notified and brought into force.
Christian Michel, the alleged middleman in the Augusta Westland helicopter scam, is back before the Supreme Court. What's he challenging now?
He's challenging a provision of the India-UAE Extradition Treaty under which he was brought to India. Just last month, the Delhi High Court rejected the same challenge and refused to release him from jail. But Michel has now moved the Supreme Court, which has issued notice to the union government on his plea. Michel, a British national extradited from the UAE in 2018, is specifically challenging a clause in the treaty that allows India to prosecute an extradited person, not just for the offences for which extradition was granted, but also for offences connected therewith. His argument is that this gives the prosecution excessively wide powers and violates constitutional protections.
The Supreme Court this week spoke about 2 serious social problems in India: dowry death and the rise in unwanted pregnancies. What exactly did the court say?
In one case, the court said dowry deaths continue to be a major problem, especially in Uttar Pradesh, Bihar and Karnataka. These observations came while the Supreme Court cancelled bail granted to an accused in a dowry death case from UP. The bench said that even today, many women are being harassed and sometimes even killed over dowry demands after marriage. And in another case involving the termination of a minor rape survivor's pregnancy that we discussed last week, the Supreme Court dropped contempt proceedings against AIMS after its earlier order was finally carried out. But during the hearing, Justice B.V. Nagaratna observed that unwanted pregnancies, including among minors, are increasing and that stigma, fear and delays in families taking decisions often make the situation worse. The court also discussed the larger social issues around this. Additional Solicitor General Aishwarya Bhati told the bench that there is a real need for better sex education within families and society so that young people are better informed and better supported.
Remember the Arunachal Pradesh case that triggered massive protests after 19-year-old Gomchu Yekar died by suicide, allegedly accusing a senior IS officer of sexual exploitation and harassment in her suicide suicide note. The Supreme Court dealt with that case this week, and does the officer get bail?
For now, yes. The Supreme Court has overturned the Guwahati High Court's order cancelling the bail granted to senior IAS officer Talo Potom. The High Court had earlier said releasing such an influential officer at an early stage could derail the investigation, especially since Yeaker had directly named Potom. The High Court had earlier said releasing such an influential officer at an early stage could derail the investigation, especially since Yeaker had directly named Potom in his suicide note. But the Supreme Court this week restored the bail granted by the trial court while also making it clear that Potom cannot intimidate witnesses or interfere with the investigation, failing which his bail can again be cancelled.
Javed Siddiqui and Arshad Ayub, two accused in the Haldwani riots UAPA case, had been granted default bail, but the Supreme Court has now cancelled it. What exactly is this case about, and why did the court step in?
So this case goes back to clashes in Haldwani in Uttarakhand during an anti-encroachment drive back in 2024. There were allegations of arson, attacks on police personnel, damage to public property, and even use of petrol bombs. UAPA charges were also invoked. Now, Siddiqui and Ayub were granted default bail by the High Court of Uttarakhand at Nainital.
And for our viewers, what exactly is default bail?
So, under criminal law, if the police fail to complete the investigation within a prescribed time period, the accused gets a statutory right to what is called default bail. That right comes from Section 167(2) of the CRPC, which is now reflected in Section 187(3) of the PNSS. But in UAPA cases, the law is slightly different. Under Section 43(d)(2)(b) of the UAPA, courts can extend the investigation period beyond 90 days up to a maximum of 180 days if the prosecution shows proper reasons for needing more time. Now, in this case, invoking the power that we just spoke about, the trial court had granted extensions to the investigation period, and the charge sheet was filed around 149 days after the date of arrest. However, the Uttarakhand High Court found the investigation to be slow and careless, and on that ground granted Siddiqui and Ayub default bail. But the Supreme Court did not agree and overturned the order granting default bail. Its reasons? 1. The High Court underestimated the scale of the alleged riots. 2. Its factual findings on the investigation, particularly the number of witnesses examined, were incorrect. And 3. The accuser challenged the extension orders far too late, after the charge sheet had already been filed.
We have some bad news for law students. The Supreme Court this week seemed quite skeptical of a Delhi High Court judgment that said students cannot be debarred on attendance grounds.
And what's interesting is that the Supreme Court was not even directly hearing an appeal against that judgment. The issue came up incidentally in another case involving Bar Council of India regulations for law students. But during the hearing, the bench openly questioned the Delhi High Court's reasoning and asked the BCI why it had not challenged the judgment earlier. Justice Vikram Nath even remarked that that ruling had created chaos for national law universities, observing that if students do not attend classes, what's the point? The court also indicated that even if the BCI does not formally challenge the Delhi High Court judgment, the Supreme Court may still examine its correctness and pass directions on its own.
And in an insolvency proceeding, can the assets of group companies be pulled in along with the main company?
The Supreme Court this week said yes, in certain situations. It held that courts can lift the corporate veil and include assets of group companies in the insolvency process of a holding company, where the entities are closely interlinked. The case involved Alpha Core Development Private Limited and the Greater Noida Industrial Development Authority.
If your name appears in the revenue records as owner of a piece of land, does that prove you own it?
Once again, the Supreme Court this week has said no. In a matter coming from Andhra Pradesh, the court reiterated that revenue records are not documents of title. They mainly reflect possession for revenue and tax purposes. Actual ownership still has to be proved through proper title documents and other evidence. The court also briefly summarized the governing principles. 1. Mutation entries are only for fiscal purposes. 2. They do not create or extinguish ownership rights. And 3. At best, they may raise a limited presumption regarding possession, not title.
If you passed every paper of the Advocates on Record exam except one, and then the Supreme Court decided not to hold the exam in 2026, what do?
You can always file a writ petition, which is exactly what happened this week. A group of advocates who missed clearing the AOR exam by just one paper have challenged the Supreme Court's decision not to conduct the exam in 2026. Their argument is that they fall in the category of candidates who only have to reappear for one paper, and postponing the exam till 2027 unfairly prejudices them. The matter was mentioned before Chief Justice Surya Kant, who did question why the candidates could not simply wait for another year. But after hearing the submissions, the Supreme Court has agreed to list and hear the matter.
Arvind Kejriwal and Manish Sisodia are boycotting proceedings in the Delhi High Court. So what happens next year?
So the Delhi High Court will appoint an amicus curiae to assist it. The case concerns the CBI's challenge to their acquittal in the Delhi excise policy matter. And if you remember, last week we discussed how Kejriwal and Sisodia have chosen not to participate in proceedings before Justice Swarnakanta Sharma. Since they are not appearing, the court has now decided to appoint an independent amicus so that the matter can still be properly argued.
And that's a wrap on this week's Courts This Week. This is Debojit Das signing off with Advocate Ostika Das here. For detailed coverage of every case we've discussed today, head over to livelaw.in and follow us on all our socials to stay updated with everything that is law. So, see you next week.